Greetings, friends. This is a short summary of the essay or article by Owen Barfield in The Rediscovery of Meaning titled Poetic, Diction, and Legal Fiction. This is the summary I would have given live for our next Urphenomen reading group meeting, but unfortunately I won't be able to be there, so I pre-recorded it for you here. So in this essay, Barfield says that what he's especially interested in is the coming into being of meaning, the creation of new meaning through poetic use of language. And he says at the beginning of this essay that the sort of essence of the poetic use of language is figurative, or is to illustrate or express something by means of something else. And he describes a kind of gamut or spectrum of this intensity, where you have the simile, where you're saying something is like another thing, to metaphor in the middle, where you say, my love is a rose, where there's a kind of like identity between the two things, and then the symbol, where it's not so clear what the other thing is that's symbolized, because they sort of collapse together, A and B, A being the meaning and B the symbol become one. And he has this sort of formula for understanding like a truly effective metaphor, which also ends up being a poetic use of language or diction that ends up producing actual new meaning. So he says that B, which is actually said, ought to be in some sense the best, if not the only way of expressing A, the meaning, satisfactorily. The mind should dwell on it as well as on A, and thus the two should somehow inevitably be fused together into a new, well, he doesn't say new here, but simple meaning. And as we've explored in prior essays, this is sort of the essence of language itself as a kind of tissue of dead metaphors that we don't recognize anymore as metaphors or symbols for concepts. And he coins this word tarning, drawing on the German word Tarhelm, which he mentions the Nazis using for their propaganda, to just refer to this general use of language to say one thing but mean another. He says, we seem to owe all these tropes in language and metaphors embedded in language to the fact that somebody at some time had the wit to say one thing and mean another, and that somebody else had the wit to tumble to the new meaning, to detect the bouquet of new wine emanating from the old bottle. And he says that admittedly this happens so quickly that you can't really track it. But there is another sphere of human life where this tarning process can be tracked, and that it's sort of the transformation of human consciousness that it illustrates can be seen in more slow motion. And for him, this is law and legal fictions that facilitate the emergence of like new meaning or new apprehensions from what he describes as the genealogical way of looking at human beings, where it's what kind of being you are and your sort of status and like what family you're born into, your skin color, whatever it might have been, that determines your rights, versus the personal way, which is more based on like how one exerts their own free will. The movement from status to contract, like this emphasis maybe from like kind of group soul oriented law to law based on free individuality. And he says in this older sort of this genealogical way, with the feudal system as one of the more recent manifestations of that, there wasn't this sort of clearly published abstract universal law, but instead forms of procedures that one had to somehow get moving in order to receive a fair hearing from the judge and take someone to court for stealing your land, for instance. But if you were a peasant, or maybe for some reason in the social context not of a favorable rank or reputation, you might not get a fair trial. So instead, Barfield mentions this possibility through the use of legal fictions, where there's a situation where somebody's the rightful property owner, but somebody else is in possession of it. And in order to cast things a different way, so that it is rendered more a question of personal property rather than inheritance of land. They tell this sort of elaborate fiction about having leased the land to someone else who then became dispossessed of it, and this is sort of like a representative of the person in court, and it gets them in front of the judge finally, and even the judge may realize that it's a total fiction, but is able to, because of the fiction, assess the justice of the situation when maybe the customs would have impeded it from happening. And so slowly this shift from the genealogical feudal system to a recognition of individual rights is sort of slowly happening through the fiction. It's not yet maybe dawning in the consciousness of this sort of abstract principle of it, but it's being brought about through this poetry of the made-up circumstance. Then he gives another example which I think makes it more clear when it comes to the rights of a woman to personal property, and like the innovation in the law that you could say is a kind of implicit recognition of women's rights as individual human beings and not just possessions of their husbands. That's like sort of dawning, but Barfield says like it's first unconscious, these sort of perception of rights such as those or that kind of justice, and it's only brought about through this legal fiction, you could say. And so he says, but by a particularly ingenious piece of tarning, the equity judges expressed in the form of law, and in doing so no doubt partly created a more modern view of the rights of married women. They followed the common law doctrine that the husband owned everything, but as to property which someone had given to the wife with the intention that she should have it for her own separate use, the courts of equity began in the 18th century to say that the husband did indeed own this, but he owned it as a trustee for his wife, and they would prevent him from dealing with it in any other way. So it's like this notion of him being a trustee is a kind of fiction covering for giving her a kind of right to her own possession without the tradition of the husband owning everything that belongs to his wife. So just to reiterate this idea that the law itself lay hidden in the unconscious until it was expressed in a judgment, and where rights themselves depended upon the existence of remedies. And this reminds me of Steiner's, the moment in Steiner's The Philosophy of Freedom, where he says there can be no science of ethics, but only a natural history of morality, where we see like these ethical intuitions like coming into existence through the sort of situated negotiation of social life. Now another great quote: the long analogy which I have been drawing may be expressed more briefly in the formula metaphor, language, meaning, and legal fiction, law, social life. It has no particular significance if poetry is to be regarded only as either a pleasurable way of diverting our leisure hours or a convenient vehicle for the propagation of doctrine. For it must be conceded that there is all the difference in the world between the propagation of a doctrine and the creation of meaning. The doctrine is already formulated, and if we chose to express it by tarning, that is simply a matter of technique or political strategy. Whereas the creation of meaning, for instance, the recognition of the rights of women, was not prior to the sort of like legal fiction example of the property ownership. It was not at that time a kind of doctrine, part of tradition. It had to be sort of realized, at least, intellectually, maybe in pre-intellectual, the very distant past and matriarchal situation, there was a different way of negotiating these things. But he then goes on to make this additional analogy between the sort of fixity of law and its universal abstract character and the logic character of language, where we're meaning something through a repeated use of the word, but that can become stultified just as abstract laws can be stultified and not sensitive to context. And so just as a poetic use of language, using a word that has traditionally meant one thing to then bring new meaning into the world, is similar to what's going on with legal fictions and the perception of new ethical intuitions. And so, just like the history of language, the history of law can be approached as a kind of site for getting to know the transformations of human thinking that have transpired over the course of human evolution. And so Barfield can write towards the end, it could hardly fail to be beneficial in far-reaching ways at a time when the whole theory of human society is in the melting pot. For instance, a deeper, more sympathetic understanding of the long, slow movement of the human mind from the feudal or genealogical way of regarding human relationships towards what I have called the personal way would do no harm. So this essay was one of the harder ones I've read by Barfield, partially maybe because I'm not familiar with law, really. But Barfield's essays are always usually a little tough the first time around, so I look forward to hearing what you all have to say when I catch up on the dialogue that you have, and sorry again I can't be there, but yeah, looking forward to next time.